Welcome to House Education, Wednesday, May 21st, 2025. I would say this morning, we are going to have what I would consider one of my favorite activities in the committee, and that is to learn about constitutional law and Supreme Court cases from our resident expert and excellent teacher on these matters. There is a case that was just a couple of cases that were just recently argued before the U.S. Supreme Court that, depending on the outcome, may have sort of significant implications. So I thought it'd be, just we have the time, be good for us to sort of learn about those so we know what to expect in the future. So I'm going to turn it over to Legislative Counsel. Welcome. Thanks for being here.
Thank you, Beth St. James, Office of Legislative Counsel. So I'm going to talk to you all about two cases today. One, I have a PowerPoint presentation on, which is really just excerpts of language from the lower court's opinion. And the other case, I do not have a PowerPoint presentation on, but I'm prepared to talk about it today. And it looks like you have some demonstrative exhibits over there.
Yes.
I just want to start by saying what we're going to talk about today are lower court cases, the decisions of which are on appeal to the U.S. Supreme Court right now. The U.S. Supreme Court has heard oral arguments, and they are likely to issue opinions in the cases that we're going to talk about today, with their slate of blockbuster cases in late June. So everything we talk about today, I mean, that's my guess. That's my guess. The Supreme Court has been busy this year, so maybe they have more blockbuster cases than I'm tracking, and maybe these will be earlier in June. We could really get an opinion on them any day, but traditionally, when there are big cases like this, they kind of come out a couple of weeks through June. And oral arguments in both of these cases were relatively recently in April, so I'm sure the court is still digesting them. So what we're going to talk about today is not the final say. So there is a chance that everything we talk about today is all moot in a month. And that when we come back next year, I will be updating you on these cases and the presentation will look very different. So I just want to kind of set those perspectives. The other is I'm not an expert on either of these cases. When I've come, and I'm not an expert on anything, I am just your legislative counsel who puts together materials to the best of my ability. I have spent a lot of time with Carson and the Carson trilogy. I have not spent a lot of time with these cases. So I am not an expert on these cases, and I am not prepared to talk about every detail and important, pertinent piece to understand these cases. What I have for you today is pretty high level, to give you a working knowledge so that when you see, if someone asks you about these cases, or you see headlines, or you see even just the opinion has been released and there's, a blurb of the way the vote went, you have a working knowledge to be able to digest that on your own. And then you can always email me for to digest together. So I'm going to share my screen. So the first case we're going to talk about is, I've been calling it, usually what we do in order to come up with a short name, the nickname for a case, is we take the first name of the party that first appears in an appeal. But that's not always what happens. So for example, in Carson, sometimes people refer to it as Macon. So there are two cases that have been consolidated. St. Isidore of Seville Catholic Virtual School v. Drummond, who's the AG of Oklahoma, and statewide Charter School Board v. Drummond, again, Drummond. Those cases have been consolidated, so there's going to be one opinion. They're essentially the same case with just two different parties, the school and then the Charter Board. I've just been referring to this case as St. Isidore. We'll see how, once the Supreme Court's opinion comes out, how everyone else is referring to it. But St. Isidore is a lot easier to say than statewide Charter School Board. So All right, background. So this is a case that's coming out of Oklahoma. So we care about Oklahoma law for this conversation. But before we do that, we're going to talk about federal law. So charter schools, which Vermont does not have, are authorized in the Elementary and Secondary Education Act, and they require charter schools to be non-sectarian in programs. That means not religious. In their programs, admissions policies, employment practices, and all other operations, and not to be affiliated with a sectarian school or religious institution. So that's federal law. That's the enabling legislation that sets up every state that has charter school policies in their state. I believe there's something like 45 states that have charter school laws. So we are definitely in the minority there. So Oklahoma established its Charter School Act in 1999. And under that act, charter schools are public schools. You will hear this a lot, that charter schools are public schools. I'm not going to debate that. But what that means in each state is extremely different. Not all states require their charter schools to follow all of the same laws that public schools do. So they may be treated like public schools for whatever purposes in that state, they are treated like public schools. But just hearing that something is a charter school is not a blanket acknowledgement that a charter school has to follow all of the same laws, regulations, et cetera, as a public school across the board. That might be true in some states, it might not be true in others. In Oklahoma, charter schools are public schools, and they are sponsored by an entity like a school district, a post-secondary school, a federally recognized tribe, or the State Board of Education. Charter schools, and so anywhere you see that paragraph symbol, this is language taken directly from the Oklahoma Supreme Court case that is on appeal to the US Supreme Court. So all of these references are to the underlying case that's on appeal, the Oklahoma Supreme Court case. So charter schools use innovative methods and forms of accountability, provide academic choices for students and parents, and offer different professional opportunities for teachers and administrators. That's how the court characterized charter schools. Oklahoma law requires all charter schools, very similar to the federal law, to be non-sectarian in their programs, admissions policies, and other operations. Under Oklahoma law, the Charter School Board is the only state body with the authority to form virtual charter schools. Okay, so now we're going to get into some of the facts. So the Archdiocese of Oklahoma City and the Diocese of Tulsa applied to the Charter School Board to establish St. Isidore as a religious virtual charter school in 2022, I believe. Or 2023, I guess. This is from St. Isidore's application. Rooted in the Catholic understanding of the human person and her or his relationship with God and neighbor, St. Isidore fully embraces the teachings of the Catholic Church's magisterium, and St. Isidore fully incorporates these into every aspect of the school, including but not limited to its curriculum and co-curricular activities. In October 2023, the Charter School Board voted 3-2 to approve a contract for sponsorship for St. Isidore. So charter schools need to be sponsored by one of those levels of at this point in the session, I'm just going to say bureaucracy. So school district, post-secondary school, federally recognized tribe, State Board of Education. So the Charter School Board voted 3-2 to approve a contract for sponsorship for St. Isidore. They had to modify the model contract they used for every other virtual charter school to state that St. Isidore has the right to freely exercise its religious beliefs and practices consistent with its religious protections.
Well, isn't that against state law though?
Sure is.
Probably why it may have been appealed to the
Okay,
Supreme Court.
so I'm sorry for stating the obvious, like,
Yes, that's why lawyers have jobs.
Did Carson play a role? Well, you probably don't know this, but did it play a role in that decision?
In the charter school board's decision?
Yeah.
Oh, I can't speak to what their decision, but we will talk about Carter or Carson. Carson is now part of the trilogy.
What are the other two?
Espinoza and Trinity.
Okay.
Trinity Lutheran. Okay. So the state of Oklahoma said, you can't do that. And they sued, seeking a writ of mandamus, directing the charter school to rescind the St. Isidore contract. Who knows what a writ of mandamus is?
You.
Jana?
Yeah, you do.
Yes.
Come on, show off.
I do.
Digging deep. Oh, is that a question?
You don't have to.
It's a writ to order them to take a particular action.
It's basically asking a court to order some governmental body to do something that they are allowed to do or to refrain from doing something they're not allowed to do. So, state of Oklahoma, their attorney general sued and said, charter school, we want you to rescind that contract. So the Oklahoma Supreme Court in Drummond, the Oklahoma Statewide Virtual Charter School Board, that's the official name of the case that's on appeal, found that under both state and federal law, the state is not authorized to establish or fund St. Isidore. That was the final line. So the Supreme Court agreed with the AG and said, you can't do this. And we're going to talk about why the Supreme Court said that. So the Oklahoma Supreme Court found that under both state and federal law, the state is not authorized. Oh, I just read that because it appears twice.
Very important.
So the Oklahoma Constitution states, no public money or property shall ever be appropriated, applied, donated, or used directly or indirectly for the use, benefit, or support of any sect, church, denomination, or system of religion, or for the use, benefit, or support of any priest, preacher, minister, or other religious teacher or dignitary or sectarian institution as such.
Can I ask a question about that? How does that play out with like Native American tribes that have their own schools, but there is a religion associated with Native American tribes?
That is a really great question that I'm not prepared to answer. I'd be happy to look into it a little bit and get back to you. But there are, depending on where the school is located, there is some sovereignty for Native American tribes.
Okay.
And it's not a straightforward analysis.
All right. I was
Yes.
just curious because I
Yep.
know Oklahoma is like
Yep.
the most concentrated state. of-
Yep. That's a very fair question that I am not an expert on.
Okay.
So Oklahoma Constitution, this is a provision in their constitution, seems pretty clear that the contract establishing a public school that is allowed to exercise their religious freedom and publicly funded might violate this, right? There's a whole lot of analysis about the Oklahoma Constitution and the where this piece came from in their constitution and the history of it. I'm not going to get into that. I don't know that the US Supreme Court will either. I'm just flagging that that's a piece that I'm not going into detail on.
That's unusual though, right? Like without going into the details, like, are you aware of other states that have?
Yeah, so this could be a whole
Yeah.
class in and of itself. But as you all know, our country, the states in our country formed at different times, right? And the country looked different at those different times, right? And so when Vermont was forming in our first constitution, 1777, it's very different than the lay of the land than when Oklahoma was writing their constitution. A lot happened in between that time period. I don't know when Oklahoma's constitution was enacted. But there's something called, do you remember when we were talking about Carson several years ago? Do you remember anything about the Blaine amendments? Okay. If that comes up in the Supreme Court opinion, we will talk about that next year. But there was a movement, if you will. I'm sure I hope there are no constitutional scholars watching this. because they have better things to do with their time. But if they are, I'm going to butcher this. There was a movement at a period in our nation's infancy where there was hostility towards religion. And so there were these amendments added to constitutions to prohibit state funds going to religious institutions, specifically Catholic organizations. And so clauses like this popped up all over the place, and they were called the Blaine Amendments. And they were very hostile to like they were formed on a hostile basis. I don't know off the top of my head if this was a Blaine Amendment. But yes, this is a thing. And should this become a big piece of the Supreme Court's decision, we can go into it in more detail. There's so much that we could talk about in this. I'm just scraping the surface.
Yeah.
But all of that aside, just looking at the plain letter of the Oklahoma Constitution seems like not okay for St. Isidore to have received its charter contract, right? The court found that expenditure of state funds for St. Isidore's operations constitutes the use of state funds for the benefit and support of the Catholic Church in violation of the Oklahoma Constitution. The Oklahoma Constitution also delegates to the legislature the duty to establish and maintain a system of public schools, which shall be open to all children of the state and free from sectarian control. Oklahoma's charter school law also requires charter schools to be non-sectarian. So the court found that changing the terms of the contract to allow St. Isidore to exercise its religious freedom violated the plain language of their Charter School Act and the Oklahoma Constitution.
They did not weigh in on whether it had anything, that it conformed or didn't conform to federal law.
Oh, we're getting there.
Okay.
This is just the state stuff. So here we go. So the court spent a lot of time, and I anticipate the Supreme Court, the US Supreme Court, to also spend a lot of time discussing whether or not St. Isidore is a government entity or a state actor. Because if it's a government entity or a state actor, then the analysis under the First Amendment, the Establishment Clause or the Freedom of Religion or the Free Exercise Clause is going to be different than if it wasn't. So the school was arguing, and there is a whole line of jurisprudence about governmental entities and state actors that I am not, we would be here all day if I got into that. I'm not going to get into it. Just know that this is important. The school argued that there was some amount of separation between the school as a private entity and the role it was serving that would make it not a governmental entity or a state actor. They had their own board, right? They're private. The court did not agree. As a charter school, the court found St. Isidore was sufficiently entwined with governmental policies, and the state itself was sufficiently entwined with the management and control of St. Isidore, that St. Isidore is a state actor. So it's not this analysis is important because if this was a public school, under the traditional thought that we think of when we think of a public school, this is a pretty simple analysis. This is the state creating a religious school. That's not okay under both the Oklahoma Constitution and the US Constitution. But we have a private entity that is contracting with the state to serve a public function. Is there enough separation there? Because the state and the federal government contracts with private entities all of the time. And they contract with religious private entities all of the time. And they don't all have to abandon their religious freedom just because they're providing a service that the state is paying for. So figuring out if St. Isidore, if this charter school is a government entity or a state actor is really important to the analysis. And so the Oklahoma Supreme Court said it wouldn't exist without the state. The state is sufficiently entwined with their management There's no way that they're not a state actor. So then the Oklahoma Supreme Court jumped to the federal analysis. So the First Amendment has a whole bunch of rights in it, including freedom of religion. And freedom of religion, if you remember back to our Carson presentation, did I do a Carson presentation here? Okay. Has two clauses. There's the Establishment Clause and the Free Exercise Clause. The Establishment Clause says Congress shall make no law respecting an establishment of religion. The US Supreme Court has held that states cannot pass laws that aid one religion, aid all religions, or prefer one religion over another. And the Oklahoma Supreme Court said, because it is a governmental entity and a state actor, because they went through that analysis based on US Supreme Court cases and helping them figure out if St. Isidore was a state actor, St. Isidore cannot ignore the mandates of the Establishment Clause. Yet a central component of St. Isidore's educational philosophy is to establish and operate the school as a Catholic school. St. Isidore will fully incorporate Catholic teachings into every aspect of the school, including its curriculum and co-curricular activities. It will require students to spend time in religious instruction and activities, as well as permit state spending in direct support of the religious curriculum and activities within St. Isidore, all in violation of the Establishment Clause. We hold that the St. Isidore contract establishing a religious public charter school violates the Establishment Clause. They didn't spend a whole ton of time talking about this. This is pretty straightforward in their opinion. What about that other part of the freedom of religion piece of the First Amendment? What about the Free Exercise Clause? So the whole clause, the whole piece reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So the board and the school both argued. So the board is the charter board that wanted the contract, and the school is St. Isidore. Both argued that the Free Exercise Clause prohibits a state denying St. Isidore its right to operate as a charter school solely because it is religious. Does this sound familiar?
Mhm.
In support of this argument, they rely on the Free Exercise Trilogy, which is perhaps my favorite phrase in all of this.
I think an exercise for the committee, well, at least those of us who've been around for, is to see if we know what Carson is, but can we remember Trinity and Espinosa? I remember one of them, I can't remember which one, had to do with like getting a grant for playground improvements on a church playground.
And that was Trinity.
That was Trinity. And then Espinosa was more education based, I think. I don't know.
Scholarships,
The scholar.
tax credit
Okay.
to religious schools.
All right.
So I have a question. I want to make sure I'm following. So for the board and the school to argue that, to make that free exercise argument, they had to be arguing that they were in fact not a state entity, right?
Yes,
Yes.
yeah, they were saying they're not a state entity.
That's at the heart of this.
Yeah.
Yes.
Okay.
And I think I have not read their briefs. I just haven't had the time. I wouldn't be surprised if they said, even if we are a state actor, you can't deny us this benefit solely because we're religious, because of the Free Exercise Clause. So they're saying you can't exclude us just because we are religiously affiliated. And Trinity, Espinosa, and Carson were very incremental in where they ended up. It started with Trinity, and then Espinosa built on Trinity, and then Carson built on Espinosa. And essentially what St. Isidore is trying to do is build on Carson and make this not a trilogy, but a what?
I don't know what it is, what it's for.
I like that.
What?
I'm pretty sure that's a man.
I was looking to our English teacher here to
Yeah,
help us
that's
out.
Folks.
And she came up with quadrology. I think we're gonna go with James quadrology. Which may or may not be a real word.
And
Google that.
I think I talked about this, I certainly talked about this 2 years ago when Carson came out. I don't know if I talked about it this year, but the law is a living, breathing thing. And it evolves and it changes. And this Supreme Court, this US Supreme Court has shown us that precedent may not have the same value that we all thought it had. And maybe that's too narrow-minded of a way to say it. But just because the laws and the cases all coalesce around a certain theory and line at one point in time does not mean that that theory and line is going to hold forever.
Yeah.
Because I think if someone came in the 90s and gave the facts of Carson, it would be a very different outcome. But here we are. And so I don't know what the US Supreme Court is going to do with this. So the Oklahoma Supreme Court said, no, we're not going to build upon Carson. St. Isidore is a state-created school. It only exists because of the state, as opposed to Carson, where the court in Carson, the Supreme Court in Carson noted lots about the differences between private schools and public schools, noted that the private school was at issue was not a public school, and further noted that the state did not cover the full cost of private schools. And then what's not mentioned in this case, but I think is important, is that in Carson, there was a bright line between the state funds and where they went, and that was parental choice, right? In Carson, parents could choose where they were sending their tuition money. This is the state choosing to send money directly to this school. So the Oklahoma Supreme Court is saying, this is not Carson. This is very different, and we can call it out based on the facts. This is a state actor. You can't do that. So I liked this quotation from the holding of St. Isidore. So, what St. Isidore requests from this court is beyond the fair treatment of a private religious institution receiving a generally available benefit implicating the free exercise clause. It is about the state's creation and funding of a new religious institution violating the Establishment Clause. Even if St. Isidore could assert free exercise rights, those rights would not override the legal prohibition under the Establishment Clause. Compliance with the Establishment Clause in this case is a compelling governmental interest that satisfies strict scrutiny under other provisions of the First Amendment. So Carson had the opposite approach, and Espinoza and Trinity building on it, with Carson being, I think, the strongest in the trilogy. There's the phrase is play between the joints between free exercise and the Establishment Clause. It is not a perfect situation. There's going to be give and take. Where is the line between religious liberty and the state going too far in either direction, either establishing or preventing the exercise of religious freedom? And what Carson said was, religious freedom, free exercise clause is going to trump any Establishment Clause concerns in the context of Carson, with all of the facts associated with Carson. And what the Oklahoma Supreme Court here is saying, the facts of this case, which is very different, is going to have the Establishment Clause trumping the free exercise clause. And so the court ordered the charter school board to rescind its contract. They got their writ. And then there was an appeal to the US Supreme Court. So what happens next? So the case, and I just cannot state how elementary this briefing is to you all, because of the limited time, my limited time, and just what we have to
Limited
do.
capacity to
Okay.
understand.
Yeah. I just, there's so much more we could talk about.
It's really informative though.
Okay.
Thank you.
So the case is currently on appeal to the US Supreme Court from the Oklahoma Supreme Court. An oral argument was held on April 30th. This is likely one of the last big opinions the Supreme Court will issue in late June. Here's what I think is really interesting. There's 9 Supreme Court justices. Justice Amy Coney Barrett recused herself.
Because she's religious.
So she's
I don't think she said, right?
I have not dug very deeply, but I have not found any like clear.
Are you allowed to do that?
Yes,
You
if there's a conflict, yes, you
But
should.
you have to establish the conflict, right?
I don't want to speculate.
Okay.
But so there's only 8 justices hearing this case. If there is a 4-4 split, the Oklahoma Supreme Court's decision stands. I have not listened to the oral arguments. I've read commentary on them. I think you can guess which justices are siding with which parties. All eyes seem to suggest that this is going to come down to Roberts.
Sure.
And there were questions on both sides of the argument from him. So I don't know. So these are how the 2 parties, I took this directly from their briefs. The first page of their briefs. I didn't go any further. This is how each of the parties are framing the issues for the Supreme Court to decide. I just thought this was really interesting. So the St. Isidore and the Charter Board are saying, these are the questions the US Supreme Court has to decide. Whether the academic and pedagogical choices of privately owned and run school constitute state action simply because it contracts with the state to offer a free educational option for interested students. My goodness, is that someone writing persuasively? Whether a state violates the free exercise clause by excluding privately run religious schools from the state's charter school program solely because the schools are religious, or whether a state can justify such an exclusion by invoking anti-establishment interests that go further than the establishment clause requires. That was a line, that is directly hearkening to Carson, because what Carson said was, yes, we are a republic of independent states that are unified in one country, and that allows for each state to have a certain amount of democratic ingenuity in their own state. But you cannot ask for more than the US Constitution requires. And what Carson said was the free exercise clause or the establishment clause, that Maine was going above and beyond what the US Constitution required. And they're saying, like, make a similar analysis here. Oklahoma, in its decision, has gone above and beyond what the establishment clause requires.
If we swapped out the words charter school program for town tuition program, it's the exact same argument.
So Oklahoma is saying this is how the Supreme Court should be framing it. Whether the First Amendment requires the state of Oklahoma to establish, fund, and oversee religious public charter schools because it establishes, funds, and oversees non-religious public charter schools. This is really interesting on many levels, but especially because there's only 8 justices hearing this case.
Yeah.
So if there's not a majority opinion, then the Oklahoma Supreme Court case will stand, and it will not be okay for Oklahoma to have contracted with St. Isidore under the current law. But that will be just for Oklahoma.
So where does the federal law that requires a charter school to be non-sectarian in its programs, admissions policy, et cetera, where does that fall into this case?
So one of the arguments that Oklahoma is making is, if you find for St. Isidore in this case, you're upending every other state, including the federal law's charter school law. So, like, did we all get it wrong?
So are you,
So just following with, so if the Supreme Court sides with St. Isidore,
How you say it?
Isidore, I could, is there any on the end?
There is.
Okay, it's Saint Isidore.
Okay, I don't, okay.
Uh, So what would the impact be on that first bullet point?
The same as it would be on the Oklahoma law.
So-
It would be upon Congress to change it if they want to, or they could leave a law on the books that the Supreme Court has found is potentially in conflict with the Constitution.
So this really wouldn't be just limited.
If the US Supreme Court rules, absolutely. If the US Supreme Court comes out with a majority opinion, then that's gonna be depending on how I should caveat that with, we don't know how narrow the Supreme Court's decision is going to be. There is absolutely the potential for the US Supreme Court to issue an opinion that has far-reaching implications, or it could be very narrowly tailored to Oklahoma. But if the Oklahoma decision has to stand,
Right.
because there is no
Just
majority
Oklahoma.
opinion, then that's really just Oklahoma, and it's going to be just the next state's going to set this up, or the
Right.
next lawsuit in Oklahoma
Yeah.
is going to pop up.
Yeah.
Okay, so just to follow up, so if it's a 4-4 deadlock and then it goes back to the Oklahoma Supreme Court having the final word, and because it's the Supreme Court of the United States, there's no appeal process beyond that, is there?
Correct. That's
So
it.
it stands.
Yep.
So, okay,
Yep. And then someone will make a lot of money on the next one.
Yeah.
all right.
So who do you think should win?
I think I'm gonna tell you.
No, I mean, that's one of my favorite things about being at this point in my career is my laissez-faire attitude towards the courts. We're all just humans, right? I mean, I think you can spend your whole career studying legal philosophy and political philosophy. And is the Constitution alive? Are we originalists? This is all an academic argument until you are subject to the laws and the opinions that are being issued. And so I certainly in my career have come up against opinions issued that I think the court got it wrong, but that doesn't mean that I don't follow the law or make my arguments based on the law available to me. But I do think that we're all humans, including the people wearing the robes, including the people making the arguments, including the people writing the laws. I don't know that there is a right or a wrong.
I don't mean to belabor, but I do find it all fascinating. Carson, which is the main case,
I'm gonna stop screen sharing.
and Carson, you said was more based on free exercise than establishment.
Yes,
And this is more based on establishment versus free exercise.
correct. Yep. Because this is the state of Oklahoma creating or putting their rubber seal of approval on a religious school that is offering a free public education.
Well, free, but they're paying for it.
Well, we're all paying for our public education, yes.
And Carson was really based on, you don't have to offer choice,
Correct.
but if you do, you
Right.
can.
Cannot,
Yeah.
right. And I don't know. We'll see what the Supreme Court does with this. But I look forward to coming back next session and digging deeper into where this has gone for you all.
Jen, and then
So this maybe is for next year, but I guess I'm confused about sort of where the argument that if this charter school, if the argument does go in the direction of the charter school being a state entity, I'm confused about when we get into the territory of some arm of the state holding constitutional rights against the state itself. Like, how exactly does that work?
Say that again?
So in part of our discussion, you were saying that part of what St. Isidore might try to say is even if they have to somehow concede that they are, a state entity, a state actor, they may still try to argue that they have some sort of free exercise rights against the state of Oklahoma. So what am I missing in not understanding how an arm of the state holds constitutional rights against the state itself?
Don't understand that last part of your
Okay.
question, but I think what I was trying to say is, oh, I guess I kind of see what you're saying.
I mean, I guess any argument is possible these days.
Yes,
right?
I guess, I mean, I
Yes.
think that's ultimately what I'm trying to say
Yeah.
is, there is a world in which, under the way First Amendment jurisprudence is evolving currently, and given the makeup of our US Supreme Court, that there is going to be some sort of finding at some point in time, whether it's this case or another one, that religious freedom is always going to trump the Establishment Clause. And so if a state is opting to have a program where they contract with private schools to provide public education, the rights of that religious entity to participate in that process is always going to trump the argument that the state is actually establishing some amount of religion in allowing them to participate. I don't know the facts of, I don't know, is this the only virtual charter school available to students? Is it, is there a need for virtual charter schools in the state? And this is the only, charter virtual, I don't know how many children, this is getting kind of into Mahmood that we're going to go into in a second. I don't know how many families would have no other choice but to take advantage of St. Isidore. And I don't know if the facts would be different or the outcome would be different depending on the options available to families. So much of what we're looking at is fact specific. But I guess all I was trying to say is First Amendment jurisprudence seems to really be favoring free exercise rights.
Yeah, I guess a bit of commentary, that seems particularly weird when we're going into the nature of a state-private partnership and how you draw those lines. That gets, in my opinion, that gets pretty scary. So that's commentary for the committee, I guess.
Josh?
Oh, wait a minute. If 3 is a trilogy, 4 would be a tetralogy.
Yes.
Oh,
Yes, yes.
A little more awkward to say a quadrilogy.
Quadrilogy.
I like
It's easier on the tongue.
tetralogy. I like it.
Just call it series too.
Would you like to switch gears?
Yeah. Cool.
Okay.
This is great, really fascinating.
Okay. So, another big case that's in front of the Supreme Court, and there were oral arguments on April 22nd, and all 9 justices heard this case, is Mahmood v. Taylor, which came out of Maryland. And it is, these are the facts. So the Montgomery County Board of Education approved a group of LGBTQ inclusive books as part of the English language arts curriculum through their normal curriculum adoption process. The court called these books storybooks. The Maryland Supreme Court called these, I'm sorry, not the Maryland Supreme Court. This is a federal case. So it was brought in federal district court, and then it went to the 4th Circuit, and then it's on appeal from the 4th Circuit to the US Supreme Court. So the 4th Circuit called it the storybooks. So I'm just going to call them the storybooks. And these were for young kiddos. These were for pre-K, kindergarten, little kids. The books are, and I'm quoting from the 4th Circuit, ostensibly used to assist students with mastering reading concepts like answering questions about characters, retelling key events about characters in a story, and drawing inferences about story characters based on their actions. The record, so this was a case that was heard on a preliminary injunction basis. So basically what happened is these books were put into classrooms. The first year they were in use, parents were allowed to opt out of their kids using these books. And then spring of the first year of these books being in use, the school board said, we're going to take away the opt-out option. They had a whole host of reasons, some of them being it was getting cumbersome. If you had an opt-out for that year, you can keep it, but the next school year, 23, 24, I believe, no opt-outs. And there were various parents that were upset about that for many different reasons. Some of them are religious, some of them were not religious. And the parents sued. And they said, you can keep the books in the school. We just want the opt-out option. That's all we want. And we think our free exercise rights are being violated because we don't have the option to opt out and due process. But you can't get to due process unless you have a free exercise violation. So it's just, we're going to just talk about free exercise.
Yeah, so my first question was, why didn't this go through state court? But that's why, right there. Okay, this is a constitutional issue.
Well, yes, and there's always litigation strategy that I'm not privy to. And so they filed their complaints, and as I hope you all know now, litigation takes forever. It takes forever. So there's a process in the meantime, while your case is playing out, you can ask for an injunction. And that is basically kind of a pause on what's happening on one side or the other while the court figures out what's the right outcome here. And so what the parents were asking for is an injunction to keep the opt-out option while the underlying litigation played out. In order to be successful on a preliminary injunction, you have to show a bunch of different things, but the main thing courts usually focus on is the likelihood of success on the merits of the case. And so if a court thinks you are likely to succeed on the merits and you meet all of the other analysis for a preliminary injunction, you may be issued a preliminary injunction. But all the court has available to it when it's deciding whether you're likely to succeed on the merits is the very limited record available to them at that point in time. So there's probably been no discovery. There's probably been no evidentiary hearings. There's probably been some affidavits filed. There's been complaints and answers filed, but there's not a lot of information. So the court had, in this particular case, a very limited record. But this is the case that's on appeal to the US Supreme Court. So the record that the court had to draw from was that the books were incorporated into curriculum in the same way that other books were used, namely to put them on a shelf for students to find on their own, to recommend a book to a student who would enjoy it, to offer the books as an option for literature circles, book clubs, or paired reading groups, or to use them as a read aloud for all students in the class. And then teachers had choice on which books they used, but they couldn't not use books. And then the teachers were also provided with support materials to help answer questions. Because the books, again, were LGBTQ inclusive books. And if these are some of the books, have you guys all looked? I haven't looked at them. Have you looked at them?
I've read them. I also have used some of these books in my own classroom because I teach a class called Banned Books. And so I ordered with the Addison County School District is going through this right now as well. And I ordered the books and read them with my high school this year.
Interesting. Okay. I'm gonna take a peek at these before I leave.
Yeah.
So the first year they were used, again, several complaints. Some of them were on religious grounds, some of them were on non-religious grounds. Again, the lawsuit was not about banning the books, it was about keeping the opt-out option. And so what the quote I pulled was, they wanted an opportunity to opt out of classroom instruction on such sensitive religious and ideological issues. So they moved for a preliminary injunction based on free exercise and due process grounds. Let's see. And so again, this is what the Fourth Circuit ultimately decided was they could not succeed on the merits. And so there was no preliminary injunction, and that's what's being appealed. Thank you, Annie. Okay, so what did the court find? So again, remember, The free exercise clause requires government respect for and non-interference with the religious beliefs and practices of our nation's people. Religious beliefs need not be acceptable, logical, consistent, or comprehensive to others in order to merit First Amendment protection. The clause protects against both direct and indirect coercion. That's the key phrase here, in my opinion, coercion. The government may not compel affirmation of religious belief, punish the expression of religious doctrines it believes to be false, impose special disabilities on the basis of religious views or religious status, or lend its power to one side or the other in controversies over religious authority or dogma. While the free exercise clause casts a wide net of protection, it does so in a particular direction, being written in terms of what the government cannot do to the individual, not in terms of what the individual can extract from the government. The free exercise clause does not require an exemption from a governmental program unless at a minimum, inclusion in the program actually burdens the claimant's freedom to exercise religious rights. If the plaintiff has established that a government action has burdened his religious exercise, then the analysis shifts to whether the government can justify the limitation under the applicable level of scrutiny. So not all burdens on religion are unconstitutional. For example, in Smith, which is good law from the 90s, laws that incidentally burden religion are ordinarily not subject to strict scrutiny if they are neutral and generally applicable. And we can spend days talking about what that actually means. And we may have to do that soon.
Term we like to use a lot.
Yes, generally applicable and neutral. I won't get into it, but there is a case that hints, a US Supreme Court case from 2021 that hints that that precedent may be no longer precedent.
Yes, you've often said that that's sort of the next.
I think that's the next frontier.
Yeah.
Okay, so the parents relying on a case that is a pretty seminal case. I mean, I learned about it in law school called Yoder v. Wisconsin, which was a case about compelling students, compelling participation in public schools that were so anti or so against the teachings of the religion of this group of people that it was actually compelling them to violate their own religious beliefs. So the parents are saying that the board's failure to provide notice and an opportunity to opt out of the storybooks coerces directly or indirectly their own children's religious beliefs and practices by exposing them to viewpoints at odds with their religious beliefs. This is what the parents are arguing. But the Fourth Circuit says parents must show that the absence of an opt-out opportunity coerces them or their children to believe or act contrary to their religious views. This coercion can be both direct or indirect, meaning that a burden exists whenever government conduct either compels a violation of conscience or puts substantial pressure on an adherent to modify his behavior and to violate his beliefs. The court noted that the record is devoid of any information about how a teacher or school employee has actually used any of the storybooks in the parents' children's classrooms, how often the storybooks are actually being used, what any child has been taught in conjunction with their use, or what conversations have ensued about their themes. The court noted that the record was not developed enough to show that the age of the students alone would amount to coercion. Oh, I don't know why I can't say that. Coercion. So there was an argument that these kids are so little that you just put anything in front of them and they're going to believe it. But the court said, well, that may be true, but that wasn't in the record. Like the record is not developed enough for that. Considering that broad claim joined with extremely limited record, we conclude the parents have not shown a cognizable burden to support their free exercise claim. As such, they have not shown a likelihood of succeeding on the merits and are thus denied a preliminary injunction. Supreme Court precedent requires some sort of direct or indirect pressure to abandon religious beliefs or affirmatively act contrary to those beliefs. And simply hearing about other views does not necessarily exert pressure to believe or act differently than one's religious faith requires. So this is in front of the US Supreme Court now. All 9 justices heard it. And I don't know what they're going to do with it. Commentary that I have read seems to be that the conservative majority will side with the parents. Now, what that actually means as far as what their decision says, I don't know.
But again, it's kind of limited to the opt-out.
Yes, yes.
There's nothing really about the books themselves.
No, but I don't know how far sweeping this opinion is going to be.
It has huge
Yeah.
implications in my mind.
Right, because all of a sudden you're opting out of everything.
Well,
Well,
yeah,
yes,
I can
that is-
imagine all kinds of things that you could.
That is
Yeah.
absolutely the chaos that would cause
Yeah.
is one of the arguments that the state is making.
So following this suit or this logic, could a person or a group bring a lawsuit against a school system that taught evolution
Absolutely.
and they just want to opt out?
Yes.
Well,
Yeah.
hey,
Okay, because I was thinking of what you said.
With the opt-out option, I don't know if you'll be able to answer this. Is there sort of an understanding that the teacher needs to create an additional curriculum?
I don't know.
Okay.
I mean, I don't know what I don't, again, because the record was so, and I have not read the briefs. I've only read the Fourth Circuit opinion. But the record was so limited. There wasn't even information on how the books were used.
Yeah.
There was information on how the books were intended to be used. But there wasn't a record of like, in this particular classroom on this day, little Joey was read this book and asked this question. And when his views seemed to disagree with the book, the teacher told him he was wrong. And he, that's not in the record. That could happen, but we don't create case law based on ifs, ands, and buts. But yes, that chaos is certainly a point that has been raised of if we start creating carve outs like this, what does that look like? Which is why I don't know. Again, this is not on the merits of the case. This is for the preliminary injunction. So there is a world and possibility that all the Supreme Court says is remands it, issue the preliminary injunction, and then decide the case on the merits, and then we get the merits case in a couple of years. I don't know, but there's definitely going to be information in this opinion that is going to be.
All right, so just to reiterate, the decision is just on the preliminary injunction.
That's what's on appeal.
Okay. That's interesting. Josh.
Could the opinion be broader than just that?
I don't know. I mean, so the analysis for the preliminary injunction is likelihood of success on the merits. And so you're doing kind of a preview of the underlying case. And so if the theory for the underlying case is the same as the preview, and the Supreme Court saying you're likely to win on preview, then you're also likely to win in the underlying case. And so that analysis is going to be informative because the Supreme Court is telling you, if we get this case on the merits, depending on what the facts are, right? Here's what our constitutional analysis is likely to be. I don't know. We'll have to see.
Do we know when that's expected?
This is another, I would assume June.
Okay,
We could get it any day.
okay.
I want to say Kennedy. The prayer at midfield, the Washington case, Bremerton. The coach who was praying at midfield. I want to say
That's what I was gonna worry about.
that came out earlier than I expected it to. A couple years ago. So maybe this will come, I mean, these could drop at any day.
And that one seems to fall within that sort of impeding the practice of religious expression.
personal religious expression, but there's a whole, and what I mean, this is what, like, there's every point that came out of my mouth or every quote that I had, there's like a line of case law I could have gone down. And so, yes, his individual practice of praying was found to be supported by the free exercise clause. But there's also a line of cases that say compelling students to participate in that is not okay. So I don't know. I don't know where they're going to go.
So wait, that one is still pending?
Kennedy?
Yeah.
No. I was trying to think of when that
How that-
opinion came out.
Yeah.
That wasn't a late June case, I don't think. I think that came out earlier.
And did they decide, I can't remember, did they decide that you cannot compel student athletes to participate in a prayer circle? I mean, what was,
I believe there's a whole separate line of case law on that.
Yeah. I would imagine with this opt-out book thing, there probably is not a long line of case law.
Not specifically on I mean, there is,
Or on just the bigger question of these.
there is certainly a body of case law related to curriculum choice.
Yeah.
And as we know, so much of education law is state. So a lot of this is not federal. A lot of this is peppered throughout the country or in the different circuits.
So this could, if this were found in favor of the opt-out.
Mhm.
Or let's say, put it the other way, if it didn't, schools today all over offer opt-outs for families who don't want their child to be doing certain, but I believe that's happening on a regular basis. But if the law says this, because of this, that may not be allowed. Is that correct? Or could you still go up against it?
I think it completely depends on what the order is, what the opinion is from the Supreme Court.
Okay.
This is not the merits case. This is on the
Right, this
preliminary
is the I
injunction.
forgot about, you're right.
So,
That's,
it's unlikely that there's going to be a sweeping opinion
okay.
that directly tells states, unless you do this, you are in violation of the US Constitution. Will there be a legal analysis that then I'm coming back and telling you, unless you do this, a court is likely to find you are, I mean, that could be, it's all very speculative, but I will be back here in January with a presentation ready to go. I'll likely, I don't know, depending on what you guys make me do this summer.
Hey, don't look at us.
Maybe, it's a bicameral process. I will likely do some memos, in my free time. But they're not going to come out. Please don't contact me the day the opinions dropped and ask for a memo, which happened last time with Carson. I'm happy to talk to you, but I'm not gonna have a memo the same week that the opinion drops. Please don't tell Bryn that.
Can you bring us back around to Carson,
Mhm.
how Maine addressed it, and what the status of that process is?
Oh, that's a great question. So Maine while the Carson case was playing out in the US Supreme Court, Maine amended their education nope. Oh my gosh.
Funding.
Nope. What we call no, Public Accommodations Act. Maine has public accommodations laws or anti-discrimination laws that are specific to their educational programs. And so they amended their education public accommodations law to say that if you want to get public tuition, you have to comply with the anti-discrimination laws, which prohibit discrimination on the basis of sex, gender identity, all of that stuff. And would it surprise you to hear that there is currently a legal challenge to that
No way.
in the First Circuit right now?
So federal.
Yeah, and that is the next frontier. That's the direct challenge to Smith. That is this. So under Smith, if laws are generally applicable and neutral, they can incidentally burden religion, right? We have to be able to function as a society. If there was a carve out for every spaghetti monster who wants to worship their spaghetti god, we wouldn't be able to function. There would be a carve out for everyone and society wouldn't be able to function, right? You have to have your police powers. And so what the Supreme Court and what case law has said up until now and currently is that as long as the law is generally applicable, so it applies to everyone the same, and it's neutral, it's not targeting religion, then if it causes you to be incidentally burdened in your religion, what are you looking at me?
No, I'm just gonna come sit friendly people.
Then, okay, I believe the Smith case, the underlying facts of Smith were related to, I'm gonna get it wrong, but it had to do with drug use that was maybe related to religion, and whether that, I think it was peyote maybe, and whether that peyote use disqualified someone, I believe, from unemployment benefits or from some government service. And there was a generally applicable and neutral law about drug use. And the holding was essentially, come on, we have to be able to knit ourselves together as a society somehow. This is where we're going to draw the line. Generally applicable and neutral. What generally applicable and neutral means has evolved over the years. I'm going to Mirandize you guys. What you say can and will be used against you in a court of law. Because when courts are looking at whether a law is generally applicable or neutral, not only is it looking at the words that I have typed on a page, not only is it looking at how the law is carried out, it is looking at your conversations and your intent and who you are hoping to sweep in or sweep out of a law when you created it. So anyway, I could talk about this. I love talking about this. Masterpiece Cake Shop comes into play here. All of this to say, the argument in the First Circuit now is that requiring a religious school to participate in the public tuition program in Maine, we know is okay under Carson. We can't exclude them because they are religious. But requiring them to comply with the anti-discrimination laws that may conflict with their closely held religious tenets also violates the free exercise clause. And so what they're essentially arguing is this generally applicable and neutral principle should no longer be the analysis that the court is doing, that there should be some stronger analysis in favor of free exercise. And there was a case in 2021, you guys are just letting me talk, right?
Yeah.
Okay.
But you don't want to leave, so it's okay.
Basically, it's in part based on the fact that the Senate postponed action on H 454 until tomorrow.
There was a case in 2021 called Fulton v. the City of Philadelphia. It was about an adoption, a Catholic adoption agency, and the city's contract with the adoption agency and a similar anti-discrimination clause requirement in the contract. There were at least 3 current sitting Supreme Court justices in concurring opinions on that case that outright said, we don't know if Smith, that this generally applicable and neutral principle should be the analysis anymore. So I think the Supreme Court is waiting for the right case to come to them. And the Maine case could be it. Could also be the Vermont case that's in the Second Circuit right now, which is a very similar, if not the exact same argument over the state boards requirement that in order to be approved for tuition, you have to follow, you have to certify that you will comply with the anti-discrimination laws. So, I don't know. It could be us, it could be Maine. But that is definitely bubbling up right now.
Thank you very much for our couple times a session constitutional law explanation.
I'll be back next year.
That's good to hear.
Oh, yeah.
You said it on the record.